Not a big surprise here. The motion to dismiss in the Bryan Kohberger case denied by the judge. His attorneys arguing that there was evidence withheld from grand jurors, juror bias, insufficient evidence for the initial indictment of Bryan Kohberger. Judge said, nope, we did everything good. He is still indicted. Nothing is going to change about that. The house in King Road also up for debate right now on if it will be torn down or not. We're going to talk about that as well. Joining me to discuss, host of the podcast Defense Diaries. Go and download that. Bob Motta, defense attorney. Bob, let's start with the motion here. I don't think, like I said, anyone's surprised by this, but from a defense standpoint, was there really truly any legs to this, or was this just an attorney doing their job and vigorously defending their client?
The latter. It
Yeah.
was definitely just an attorney doing her job, filing what she felt needed to be filed. Look, like when you're talking about pretrial motions in a case like this, what you're trying to do as from the defense side of it is avoid down the road missing steps that should have been taken so that this thing gets kicked back on appeal if he's convicted. So, I mean, like you're going to see motions that the one with respect to, and there were two motions attacking the grand jury indictment, right? There was the one that you were just talking about, and there was the one that went kind of on the historical argument, saying that the Constitution of the state of Idaho, basically, which would be the law of the state, like that, like the Constitution, the state Constitution of Idaho, would be the highest form of the law there, and that essentially she was arguing that, look, the Constitution says that in a grand jury, that they basically have to meet the same standard that they do in a trial, which is beyond a reasonable doubt, which is absurd.
Mhm.
Like, but she was making, I mean, technically, because at some point the legislature in Idaho changed it, and that was in writing in terms of, it's a different standard. It's a much lower standard, a probable cause standard for, to get an indictment. And that was in writing, and her argument was, well, the legislature can't override on its own accord what the Supreme Court has written in terms of, or not the Supreme Court, but what the Idaho Constitution says. So, like, it was a technical army. Like, I knew it had zero legs. I
Mhm.
mean, clearly they were never gonna to say, okay, yeah, you're right. The burden of proof at the grand jury is beyond a reasonable doubt. Like, you knew that wasn't going to happen. Like, I just kept saying, I think that was like probably like an argument that Ann Taylor talked about, like at dinner with other lawyers for like years, and it was just like kind of waiting for her opportunity to make it. It's like, so like that thing had zero legs. Like from the defense side of it, I knew that there was zero chance.
It,
And frankly, had they been granted, they would have just re-indicted him.
exactly. Yeah. I mean, it really would have gone absolutely nowhere. I mean, things like this, are we expected to continue to see motions like this put out there to keep delaying, to keep slowing down the process of this, to push that trial out as far as they possibly can? Is that the goal right now, to get this thing kicked into late 2024, 2025, however far they can push it? So it's, there's a little less sting to this whole
No,
story, or are they wanting to get it into the courtroom quicker?
well, there's two aspects of it,
Yeah.
and like I can just tell you from a defense attorney's perspective, the motions that have to get filed, and they'll get progressively more interesting. Like the early motions, like this thing was kind of a pro forma motion where you file them just attacking the indictment initially. When we start getting into suppression motions, that's where we're going to get into the real stuff. And we know that there were issues with the house in terms of there were kids running around in it for hours before law enforcement was called. There's going to be issues with whether or not the crime scene was compromised. I mean, there's going to be issues with respect to the sheath and whether or not that's admissible
Yeah.
in terms of the DNA, and there's going to be either a Daubert or a Fry hearing on whether the DNA is sufficient to be admissible as evidence. Like, so all those things are going to happen.
Yeah.
and to answer your question is like that just takes years, man.
It
Like
just is what it
this
is.
isn't a slow play by the defense because frankly, the longer it takes for this thing to get to trial, you know what law enforcement's doing? Investigating.
Yeah,
So the longer you give them to investigate, and believe me, they are not done investigating. They are still digging around. I guarantee you they're still looking for the knife.
mhm,
Guarantee it. Now, are they out there like manhunt style? No, but they're definitely continuing to try to build a case, and that'll go up until the day of trial. I
sure.
mean, like I've tried cases like this where like it took 3 years and they we were still getting discovery up until weeks before trial.
Yeah,
They're trying to always improve their case. If they're getting like they'll send the DNA to different labs if they can get, if the say for instance the DNA technology improves over the next year or two, which is not out of the scope of reason. I mean, with DNA, it's unbelievable the advancements we see. So if there's issues that it's a trace amount and it's not a great profile that they were able to put together from what was there, and there's advancements in the technology, they're going to, if there's any of it left,
yeah,
to run another profile and build another profile on it, they'll do it. So like it's really not a huge advantage, and Kohberger's in prison.
yeah,
Like, usually or he's in jail, but, like, you're making that argument, like, they're trying to delay it when a guy's out, which
sure.
typically is
Yeah,
not the case in murder cases. Like, the guy is incarcerated. Like, he's not living a luxurious life. He's incarcerated. People are like, "Oh, he's wearing a suit to." The reason he's wearing a suit is because of the incredibly, like, I don't know since maybe OJ that there was a case that's garnered this much interest, and we've had big ones. We've had,
yeah,
like, Murdoch, like, the world was watching, but, like, when you think about the level of media attention that case, the Idaho 4 case got when it broke,
mhm,
in recent memory, like
yeah,
pre-arrest, I cannot remember a case that got that much media attention. It
sure.
was like it took over the world, man.
Mhm,
It was like even people that aren't into true crime were aware of it. You,
yeah,
you know what I mean? It was that type of case. So, in a perfect world, in order to, basically take that argument away from the defense about what a person is wearing in a court of law and how that affects potential jurors, because like people just think when, like, there's a reason why when you watch a trial defendants wear civilian clothing.
mhm,
It's because you cannot put a person in that orange garb there,
mhm,
okay, sitting at trial, because it gives
yeah,
the sense to the jury that the guy's guilty, like, subconsciously. You're just
sure.
looking at a person in prison garb, and you're like, "Oh, okay, well, the guy's guilty. He's in
Yeah,
jail." So it's like that's why, and with Kohberger, where they were televising everything, and because of the massive media coverage, and because of the potential to taint the jury pool, that's why they're allowing him to wear suits.
yeah,
It's like, I would make the argument that, like every defendant should be able to dress in civilian clothing, but the reality is that 99% of most cases are not televised.
mhm,
Most court appearances are never seen, by the public at large.
sure.
So it's like, why is the jail going to go through the problem of letting somebody get dressed in civilian garb, which is a whole
Yeah,
process, as opposed to just grabbing all the guys from the jail that are on the call that day, they stick
mhm,
them in a holding cell, and the judge calls them out. You know what I mean?
sure.
So, but yeah, like in terms of like the delay, I mean, just
Yeah,
it's the nature of the beast, man. It's not just Kohberger. It's every major case takes two,
sure.
3, 4 years to get to trial. It's
Yeah.
just the wheels of justice turn slowly, my friend.
Hey, it's Tony Bruschi. If you like the podcast, be sure to like, subscribe, and press that bell so you don't miss any of our updates on the cases we're following for you right here at the Hidden Killers podcast from True Crime Today. And thanks